Alright, everybody, how we doing today? The upload of this video is going to be a little late. Things got a little crazy here, but make a long story short, from Reason, it says, Judge rules feds need reasonable suspicion before searching tech devices at the border. Fourth Amendment protections against warrantless searches are reduced when entering the country, but they're not completely erased. Border agents who seize and search people's tech devices at entry points in the United States without any suspicion of criminal activity are violating Fourth Amendment rights, a federal judge ruled this week in a case likely headed to the Supreme Court. The American Civil Liberties Union, the ACLU, and the Electronic Frontier Foundation sued in 2017 on behalf of 11 travelers, 10 American citizens, and 1 permanent resident who were ordered by Department of Homeland Security officials to let them review and copy the contents of their devices without any other sort of warrant or explanation of what agents were looking for. Also, the CBP and Immigration and Customs Enforcement, ICE, officials have been arguing the authority for these warrantless searches on the basis of the so-called border search and search exception. Courts have traditionally ruled that America's sovereign interest in controlling who is allowed to enter its borders permits officials to search people and property coming into the country or within 100 miles of a border, without needing a warrant or any sort of suspicion. While this has historically been a mechanism for fighting smuggling in a post-9/11 era, it has been escalated into a demand to search people's technology and access their files and contents each year. CBP searches tens of thousands of devices of people crossing the border. Slippery slope at its finest. People used the aftermath of 9/11 and the fear of terrorism in order to institute new laws which were unconstitutional and therefore illegal. But did that stop the dirty politicians and the government from getting what they want? Of course not. Nothing ever does. And if you set the 9/11 conspiracy aside, the thing is, it doesn't have to have been an inside job to result in what it resulted in. The precedent creates itself, and now they can begin using a slippery slope, which is not a fallacy, it is real. And it has been poorly explained in the past, but it is true. Once you set a precedent, all it takes is one logical stretch, and then you get a future action out of a past precedent. That is the slippery slope. In a nutshell. But in a 48-page decision in Al-Assad versus McAleenan, handed down Tuesday, Judge Denise J. Casper of the U.S. District Court of Massachusetts ruled that there are limits to the extent that officials can engage in warrantless, suspicionless border searches. And these intrusive tech searches cross the line, violating the Fourth Amendment rights of the plaintiffs. While it's true Americans should expect less privacy at the border, it doesn't mean they have absolutely none. Now, in the ruling, Casper notes that unlike border searches of property and vehicles looking for contraband people might be trying to smuggle into the country, these tech searches are typically about accessing data that officials argue may alert them to criminal activity. But that's similarly true of the data tech devices once they're inside the country, and police still need to get warrants to search them. Casper notes that DHS is defending these searches by claiming that they might catch contraband like child pornography, but DHS did not provide any data as to how frequently such contraband is found during random searches. Casper further notes on a more technical level that these tech searches are not routine because of the exceptionally intrusive nature of looking through a person's phone or laptop, compared to searching somebody's luggage or vehicle. Some of the data officials accessed through the plaintiff's tech devices included confidential communication, which attorneys email and text messages, histories and troves of deeply personal information. Some plaintiffs' devices were seized and kept for weeks before they returned, after border officials had copied the content of the files into their own systems. I personally have a friend who took a trip to see his girlfriend, and it's been a while since it happened, but I'm pretty sure that the TSA searched his freaking device, and they basically erased everything on it in suspicion of piracy, because he didn't have any physical copies on him. Yeah. Can we please just abolish the TSA now? These guys are basically criminals. And they've been caught stealing people's money before, as I obsessively fix my hair, because the But no, but they obsessively, they stole people's money before. They've been literally caught on live footage. So can we please just, like, have them, abolish their asses? We don't need them. But in the end, Casper denies the plaintiff's request to force the feds to expunge all the data they've collected from their tech devices. But she does declare that the current guidelines for border tech searches by CBP and ICE violate the Fourth Amendment rights of the plaintiffs because the guidelines require no reasonable suspicion that the devices contain contraband to justify extensive searches and seizing the devices and copying of the contents. But she stops short of putting in place an actual injunction prohibiting the feds from continuing these searches while DHS considers its options. It seems obvious that this case will be fought all the way to the Supreme Court for now. The ACLU and the EFF are celebrating the ruling. The two organizations put out a joint statement. The ruling significantly advances Fourth Amendment protections for the millions of international travelers who enter the United States every year, said Esha Bendari, staff attorney with the ACLU's Speech, Privacy, and Technology Project. By putting an end to the government's ability to conduct suspicionless fishing expeditions, the court reaffirms that the border is not a lawless place and that we don't lose our privacy rights when we travel. This is a great day for travelers who can now cross the international border without fear that government will, in the absence of any suspicion, ransack the extraordinarily sensitive information we all carry in our electronic devices, said Sophia Cope, EFF senior staff attorney. Politicians in politics today do not like the fact that people have these rights enshrined in the Constitution and the law, because these rights prevent them from establishing a tyrannical state, and they want it. Beto O'Rourke wants to take your guns and tax churches. That's tyranny. That's unconstitutional. And there's other forces such as Donald Rumsfeld, who created the unconstitutional Patriot Act, which is also a violation of similar rights. There are politicians and forces within our government that don't want you to have these rights and want to have a tyrannical state. The evidence is clear. The writing is set in stone. And yet people refuse to listen. Still, this is a great victory for the Fourth Amendment. So let's celebrate that. But next stop, maybe we can stop Facebook from doing what it's doing, collecting data on people. Shouldn't that be considered a Fourth Amendment right violation? Who knows? Anyway, peace.